Welcome back to Lost Us channel. My name is Anton Vyeltsin. I'm a criminal defense attorney in the Southern District of California, here in San Diego. You're now watching the fourth video in a multi-part series dealing with conspiracy law. In the first video, I give you an overview and a roadmap of where we're headed. In the second video, we discussed Pinkerton liability. In the previous video last week, we've discussed the elements of the crime, the elements of conspiracy, and now in this fourth part, we're going to be dealing with joinder. What do I mean by that? Well, it's an agreement between two or more people, right? That's what the conspiracy is. How do we try individuals? Do we try them together or separate? And what happens when one person confesses to a crime while the other one doesn't? But then you have a joinder, you have a trial together. Obviously, one confession will have a negative impact against all the co-defendants. So what do we do in that situation? Let's discuss it in this video.
And now, on with the opera.
Thank you for joining me in this fourth part where we're going to be diving deeper and deeper into conspiracy law. And today we're going to be discussing prejudicial joinder. For those of you who are non-lawyers, what do I mean by joinder? I mean joining two or more people together in one trial. And when I say prejudicial, I mean harmful. Because a lot of times when you put two or more people together in one trial, the evidence kind of mixes together, and the jury sometimes doesn't understand which part of the evidence goes to one defendant, which one goes against the other one, and there is harm that both of them will be convicted even though one of them might be innocent. Something to remember, the Supreme Court told us before that you have a constitutional right to a fair trial, but you do not have a constitutional right to a perfect trial. Often enough, situations come up during trial that are prejudicial to the defendant, and we can't always control them. But sometimes we can. And today we're going to discuss Bruton versus United States, a 1968 case from the Supreme Court. Here's what happened. Mr. Bruton and Evans were charged with armed postal robbery. Of course, this is 1968, so we're not exactly talking about Amazon. We're talking about United States Postal Service. Mr. Bruton kept his mouth shut. And that's why I drew this face with a zipper. He didn't say anything. But Evans confessed to the crime. He said that both him and Mr. Bruton committed the armed postal robbery. They're tried together in one trial. The trial judge instructed the jury to disregard Mr. Evans's confession as to Mr. Bruton, because after all, Mr. Evans is now not testifying in trial, so he's not saying anything. He's using his Fifth Amendment right to remain silent, and he doesn't say anything during trial. But the prosecution is still using the previous confession in trial. And they used it against Bruton, somebody who never testified and also never confessed to the crime. The Supreme Court tells us that despite the instruction to the contrary, to disregard this confession as to Mr. Bruton, there's a substantial risk that the jury looked at the incriminating extrajudicial statements in determining Bruton's guilt. What do I mean by extrajudicial? Extrajudicial meaning that now, again, Mr. Evans is not testifying in trial. So we're using these hearsay statements made previously, the confessions, against Mr. Bruton. And they used it, there's a substantial risk that they used it incorrectly. There's a lot of wonderful language in this case. Non-admissible declaration cannot be wiped from the jurors' brains. And I will add more to that. They cannot be wiped from any of our brains. If you think about it, once you hear a piece of evidence, you cannot unhear it. It is simply impossible for our brains. It is also impossible for us to forget about it. That's not how that works. That's not how our brains work. The jury cannot segregate evidence into separate intellectual boxes. Again, it is hard for us as humans, and we shouldn't be asking that from jurors, to segregate, meaning take a piece of evidence and somehow say that we can use it against Mr. Evans, but we cannot use it against Mr. Bruton. Well, that would never work. Our brains, again, don't function like that. It is a naive assumption that prejudicial effects can be overcome with instructions. Again, the Supreme Court says, just because you instructed somebody about it, doesn't mean the jury can follow it, because as humans, we cannot. Practical and human limitations of jury system cannot be ignored. Limiting instructions are not adequate substitutes to constitutional rights to cross-examination. That's exactly what happens here. You have a Sixth Amendment right to cross-examine any witness that speaks against you. And here, they're using Evans' confession, but Mr. Bruton cannot even cross-examine him because we're using extrajudicial statements, not the ones where Mr. Evans is testifying in court. So cross-examination is impossible. To finish off this video, what do we do in this situation? What can be done other than the instructions? Here's the 3 things that need to be done. 1, exclude Mr. Evans' confession completely from trial. Number 2, redact. Take the statements against Mr. Evans, but redact against Mr. Bruton. Of course, that might be difficult to do during trial. And finally, maybe the best option is to sever, meaning have 2 separate trials. One trial against Mr. Bruton and one trial against Mr. Evans. Of course, the prosecution doesn't like that usually, because if you have 2 separate trials, it takes more time, it's more expensive, and the prosecution has an advantage when you join people together. Because again, our brains cannot segregate which evidence goes against which defendant. I hope you now understand a little bit more about conspiracy law, and something that comes up quite often in conspiracy, if not always, because in conspiracy law, we always have 2 or more defendants tried for a crime, because that's the definition of conspiracy, an agreement between 2 or more people to commit a crime. If you enjoyed this video, please click like, subscribe, hit that bell notification button, so next time I post, you'll be first to know. Thanks for watching.